I'm Las Vegas attorney Ryan Alexander. I represent people who have suffered discrimination or have been sexually harassed at the workplace. Before we can file a lawsuit for discrimination or harassment, we first need to file a claim with an employment agency at the state or federal government level. In Nevada, that's either the NERC or the EEOC. Both have very similar functions and some subtle differences depending on what type of claim we're making. We will file with either one or the other and begin an agency review process. Either agency has to have your claim for 6 months before a lawsuit can be filed in court. What happens when we file the claim with the agency? Well, the first thing they're going to do is they're going to set an interview with you. I will usually attend that interview, and we will discuss with the officer what happened at work. They'll give some initial guidance as to whether they think that the claim is worth pursuing. Next, the commission will spend at least 6 months investigating your case. In some matters, they'll get a response from the other side, and they may offer to begin a mediation process where we might be able to resolve your claim without filing a lawsuit. However, in most cases, they will have to close your file and we will have to serve the lawsuit on the other side before we come to a resolution. Depending on which agency reviews your file, we will file your lawsuit in either state court or federal court. So if we file in Nevada, what we call district court, in the state court, it will proceed much like any other civil lawsuit. If we file in federal court, because we've gone through the EEOC instead of the NERC, then it has a special process called the early neutral evaluation at the beginning of the lawsuit, which is a mediation with a federal judge. This will happen approximately 3 months after the lawsuit is filed. And what it is an opportunity for us to sit down with the other side and a federal magistrate judge, who's not the judge on your case, but is a judge who reviews employment cases. We'll present our side, and then we will break, and the judge will go back and forth and meet with each side individually and discuss dollar values on what the case could settle for. And the purpose of that is to settle the lawsuit without having to go through an extended period of discovery or going through a trial, which is very costly and expensive. Often, the E&E process is a good chance to evaluate the strengths and weaknesses of the case, and in many circumstances, the defendant will make at least an initial offer to begin the settlement discussions. If you have any other questions about filing an employment lawsuit in Nevada, call me, attorney Ryan Alexander, at 702-222-3476, and I'd be happy to give you a free consultation about your case.